Hello, this is Michael Lowe again. Today we're going to talk about mandatory minimums in federal drug cases and ways of getting around them. And the one way I want to talk about today is something called safety valve. This video is going to be broken up into 7 parts. The first part is just going to be what is safety valve, what are mandatory minimums, and when do safety valve apply in certain cases. The next 5 parts are going to be the 5 requirements of safety valve. And each one of those requirements, I'm going to go into some detail about what it is that the defendant must meet in order to meet the requirement of safety valve under those 5 standards. And then the final part, I want to talk about the applicability of safety valve in the real world. And I want to give you some real world examples of mistakes I've seen other lawyers make with regard to safety valve. What is safety valve? Before we talk about what safety valve is, first we have to talk about mandatory minimums on federal drug cases. And I know there's a lot of different types of federal drug cases. So the ones I want to focus on today are the 10 to life cases and the 5 to 40 cases. Those cases are found in 21 U.S.C. 841 B1A and B1B. And if you don't know if you have one of these types of cases, all you have to do is look at your indictment, and the citation to the statute will be in your indictment. If you don't have your indictment, I can provide it to you. If you have one of these mandatory minimum cases, the federal judge cannot sentence you below the mandatory minimum. So for a B1A case, the judge can't go below 10 years. And on a B1B case, the judge cannot go below 5 years. But there is an exception to that. And the exception is found in 18 U.S.C. 3553 subpart F. That's what most people call safety valve. Now, safety valve is not found in the statute, but it is an exception to the mandatory minimum rule. In this video, I'm going to go through the requirements that a defendant must meet in order to establish that exception. There's 5 requirements, and I'm going to go through each one of those. And then at the very end, I'm going to talk about real-world applicability and tell you some examples of how this actually plays out. So the law 3553, subpart F, safety valve, is going to be on the screen now. Here it is. The first part I want to talk about right now is just the criminal history points. The defendant has to meet the criminal history point standard. Now, the criminal history point standard used to be, before the First Step Act was passed, used to be just 1 criminal history point. So if a defendant had more than 1 criminal history point, they would not qualify for safety valve. The First Step Act changed all of that. The new law says that if you don't have more than 4 points, you can qualify for safety valve, as long as you don't have a prior 3-point offense or a prior 2-point offense. Now, what do all these points mean? Well, the points can be found and calculated in the U.S. Sentencing Guideline 4A 1.1. I'm going to show you that on the screen now. As you can see, this is complicated, so I'm going to explain this to you a little bit, but not in too much detail because that's not the purpose of this video. Basically, you can have a 3-point offense, a 2-point offense, or a 1-point offense. And those different types of offenses are going to vary depending on whether it's a violent crime. The number is going to vary depending on the length of the sentence. And so that's how 4A 1.1 works. As long as the defendant meets those 3 requirements under the first part, under criminal history category points, we can go on to the second part. Now, the second part of safety valve under 3553F has to do with violence or threats of violence, or whether or not the defendant possessed a firearm. In most federal drug cases, there's not going to be violence or threats of violence, although that does happen occasionally. but it's much more common for there to be a firearm involved in a federal drug case. And it's important to note that under Fifth Circuit case law, the definition under 3553F for possession of a firearm is actually different than the definition that you normally would find under the U.S. sentencing guidelines. And the guideline I'm talking about is the 2-point enhancement for possessing a firearm in furtherance of a drug trafficking offense found in 2D1.1B1. And what is that difference? This is an important difference. In a conspiracy case, a defendant can receive a 2-level enhancement for possessing a firearm, even if they didn't actually possess the firearm, as long as a co-defendant in the conspiracy possessed the firearm and that possession was foreseeable to the defendant. That's a very loose standard. However, Fifth Circuit case law says under 3553F, the standard is much higher. So in order to be disqualified under 3553F for possessing a firearm, the defendant would have to be actually in possession of the firearm or in constructive possession. So it's a little more difficult to be disqualified under that standard under 3553F. And there can be scenarios where someone may receive a 2-point enhancement under the guidelines under 2D1.1B1, but still be eligible for safety valve. So it's important to not give up, and it's important to dig in and do the research on what the definition of possession is for safety valve on possession of a firearm. The third requirement under safety valve is that the defendant's role in the offense did not result in the death or serious bodily injury of someone else. Now, how can this happen in a drug case? Well, there are many types of drug cases where the drug involved can actually kill you. And these are going to be more common in the Xanax and heroin cases. Those types of cases, there are deaths. And in a federal drug case, there's a special definition for death resulting from the distribution of a controlled substance. And that's what we're talking about. So as long as the defendant didn't distribute a controlled substance that resulted in somebody dying or having serious bodily injury from that substance, then they're going to be able to meet that requirement under safety valve as well. The fourth requirement is that the defendant not receive a role adjustment in their calculation under the federal sentencing guidelines. What is a role adjustment? A role adjustment is where a defendant in a conspiracy is said to be either a leader, an organizer, or a supervisor of other people in the conspiracy. These are specialized definitions found in the sentencing guidelines. I'm not going to get into that here in this video, but just be aware that when you consult with your lawyer about your guidelines, it's important that the defendant not receive any role adjustment or any upward role adjustment in the case in order to qualify for safety valve. The final and fifth requirement of safety valve is really the one that I think most defendants have the most difficulty understanding and wanting to comply with. So I want to really explain this one well. This is called what I call the full and complete truthful information requirement. And what does this mean? Basically, the defendant is required under 3553F subpart 5 to provide truthful and full information about everything they did to law enforcement, and also everything that was part of the common scheme or plan related to what they did to law enforcement. The rule does not require a defendant to cooperate against other people in a conspiracy. The rule does not require the defendant to provide new or additional evidence for the government's use against other defendants. And the rule does not require the defendant to cooperate with the government actively against unindicted co-conspirators. This is a big misunderstanding that a lot of people have. It is commonly thought that by defendants that they have to cooperate with the government and that their name is going to appear in a piece of paper against another co-defendant from this meeting, and it's going to be somehow used against other defendants or other family members. And that's simply not true. These meetings are designed simply to meet the requirements of safety valve. And if you have a lawyer with you who can limit the scope of the meeting and make sure that law enforcement is doing what they're supposed to do during this meeting, there can really be no harm from having this meeting. It's important, again, to qualify for safety valve so that we can get a sentence below the mandatory minimum. So it's going to be incumbent upon your lawyer to contact law enforcement to let them know that you'd like to have a safety valve interview, and they're going to know what that is. And then it's also important for your lawyer to be present during that interview and make sure that law enforcement limit their discussion with the client to just the requirements of safety valve and nothing more. Finally, I want to talk about what all this means. So we've talked about the 5 requirements. We've talked about the applicability of safety valve in certain 10 to life cases and 5 to 40 cases. Now we need to talk about how this actually plays out in the real world. And I want to give you an example that happened in one of my cases. So without going into names of defendants, I don't want to talk about that. I had a case in Corpus Christi in the Southern District, and that case involved several different defendants who were all involved in a conspiracy to distribute methamphetamine. And my client would have qualified for safety valve, and all he had to do was meet with law enforcement and satisfy the last requirement of safety valve. And I made sure that he did that, and I was present for the interview, and I kept law enforcement on a very short rein and made sure that my client didn't have to cooperate against other co-defendants or do anything outside of what his minimum requirements were under safety valve. Essentially, I made sure that my client was not going to be a snitch. Because I did that, that allowed the judge to sentence my client below 10 years. And you may want to know, how does this happen at a sentencing? Basically, the way it works is the government will verbally, on the record or off the record, tell the judge that the defendant qualifies for safety valve. The reason why the government does this is because the government doesn't want it to be in writing that a defendant gave a statement to law enforcement. And that's what happened in my case. And so my client was able to receive a sentence below 10 years. And in particular, in this case, my client had a guideline of about 14 years and ended up receiving a sentence of 8 years from a judge in Corpus Christi. And I know 8 years sounds like a lot, but in a federal conspiracy to distribute methamphetamine case, that's a really good sentence. But the interesting part of the story is that the same day that my client was sentenced, he was sentenced at the very end of several other sentencings from the same conspiracy. And my client was in the holdover with all the other defendants who had already been sentenced by the same judge. And because I was familiar with the facts of the case, I happened to know that pretty much all the defendants, the other defendants, were also eligible for safety valve. And I talked to the agent before the hearing, and the agent told me that they never came in to debrief. So their lawyers never contacted the agent to have them prepare so that they could receive a sentence below 10 years and qualify for 3553F and get a safety valve sentence below 10 years. When my client received his sentence of less than 8 years, he went back and told the other defendants about what his sentence was. Those other defendants all received sentences of 10 years. Now, the judge didn't say in those other cases that he would have given a sentence below 10 years had they qualified for safety valve, but to me it was clear that the judge wanted to give a sentence below 10 years. And that's the important thing to remember about safety valve. The mandatory minimums are real. Federal judges will not sentence a defendant below the mandatory minimum unless they're authorized to do so by statute. And I can't tell you how many times I've been to a sentencing where I've seen judges tell defendants, look, I would love to give you a sentence below 10 years. I'd love to give you a sentence below 5 years. I just can't do it. My hands are tied. I have to give you 10 years. It happens all the time. But when you qualify for safety valve, the judge cannot say that. The judge can sentence below 10, can sentence below 5 in those cases. And in those scenarios, it's very common for judges to exercise that power and give those more lenient sentences. So safety valve really is an important part of federal sentencing in a federal drug case. And I hope you found this video helpful, and I hope that you learned something that can really help you in your case.